Good evening and welcome to tonight's episode of the Late Night Intercourse with Chioma. Of course, your host is Chioma Onyenucheya Uko, also known as the Zest Family Lawyer. So tonight, we will be discussing making a will. Yes, we're discussing will making. So, what is a will? Why are we talking about a will? Who can make a will? When is the right time to make a will? And all of those. I will gladly answer all of that questions and any other that you drop in the comment question or that you need my reaction on. So that is to say that as you listen along with me, if there is any question you have or anything you'd like for me to clarify or elaborate on, feel free to drop a comment or a question on the comment section and I'll gladly respond. So let's dive straight into it. What's a will? So a will is a legal document, a testament of the wishes of a person on how he or she wants his estate to be administered or shared after his death or her death. So that is to say that it is a legacy document that somebody enters into or drafts, showing his or her intentions for what he or she wants, or how he or she wants the things he or she has acquired, the things they have, how they want those things shared amongst maybe their loved ones, their family, or any other person. So what that means is that it is an estate plan that somebody adopts for after they have passed. So it's a way of ensuring that even when we're no longer here, after we have gone to the great beyond, that the things we have toiled for, the things we have acquired, get into the hands that we prefer they get into. So it is the way a person can have a say in the administering of their affairs after they have left here. And I think that's a brilliant thing for anybody to do. So then you ask, who can make a will? And why should anybody make a will? Starting from why anybody should make a will. It is important to make a will because we have seen from many, instances that if we do not make a choice or record our choice, make clear our choice as to what we want to happen to our estate, the way some other people carelessly didn't. After they passed, their loved ones were either caught up in, quarrels, skirmishes around how things ought to happen or how the things they have left behind has to be shared amongst them. And sometimes the people who who the deceased may not have preferred, may be the ones who gain control of the assets or, the things they acquired and left behind. And it is a way of taking care of your loved ones, though the deceased is no longer there at the material time. So the way we all look out for our children, look out for our aged dependents, look out for that maybe charity cause or one organization that we care about, the way we look out for the things we care about and the people we care about, a will affords you the opportunity to continue to do that, even when you are no longer here, such that it will only be those that you want to benefit from your estate that actually does benefit from your estate. So who can make a will? So long as you are above 18 years, so long as you have an income, maybe, you have a career or you have a business, so long as you have dependents, whether they be your children, your spouse, your aged parents, your siblings, or maybe some other people you cater for as a charity cause. So long as you have an asset, any valuable at all, it doesn't necessarily have to be a landed property. It can be anything. So long as you have anything of some value, then you should make a will. And the interesting thing is that when you make a will, if you make a will tomorrow and you live until you're 120, you can continue to revise your will, amend your will, or make additions to your will until, when it's over here. So that means that making a will today does not mean that you're dying tomorrow. No, that's not what it means. It also does not mean that you're beckoning death. No, that's not what it means. Making a will, just the same way you try to guard the rest of your assets and protect your things and ensure that your things don't get into the wrong hands, making a will is also a way of ensuring that whatever little assets you garner, whatever little things, you acquire, when you leave, will get into the right hands. And yes, it doesn't mean you're living today. So you can continue to improve, amend your will as the years go by until, whenever it is that is no longer possible. So, and what are the things you should consider when you're making a will? Of course, the first thing will be to be clear on what your assets are. So that means that you should keep a deliberate record of all the assets that you have. And like I said earlier, an asset doesn't necessarily mean maybe a car or a land or a house. No, it can be those, but it can be many more things. So it means that your asset can also include things like intellectual property, other valuables like maybe a memorabilia that you are fond of, maybe an artwork, an inheritance, stocks, any financial acquisitions, cryptocurrency, all of those. It can be any and everything that is of value to you. Of course, yes, including cash and money in the bank. So if you have any assets, the first step will be to be clear in ensuring that you list out all of those assets. And of course, as the years go by, as your assets increase, you keep adding and modifying the will. As your assets maybe, change in fortune, maybe you sell an asset or an asset is lost or an asset, is no longer of serious value and you no longer think it's something you want to retain in your will, all of those allow for continuous amendments to your will or additions in the forms of a codicil. So it means that you must first of all clearly list out your assets and continue to do so as the years go by. Then the other thing will be for you to clearly list, name your beneficiaries. Who are the people you want to benefit from your assets when you're no longer here? I mean, of course, that could include your children, your spouse, your parents, your siblings, your friends, your relations, your pets, or even a charity, maybe some cause, some organization, some charity cause that you believe in. So it could be that you're saying, I want this to go to maybe International Federation of Women Lawyers. I want this to go to maybe a religious organization or a humanitarian organization or, a research institute or something. So clearly list out all of those. Then you carefully identify and select who you want as your your executor. So who is an executor? That person or those people who you're going to entrust with the duty of ensuring that your intentions as listed in your will, as clearly stated in your will, are carried out. So it is best to ensure that the person who is going to be the executor is not a beneficiary. That way, certain contests or arguments and some of those things around contesting a will are easier when those separations are clearly made. And it's also best to ensure that you don't just appoint one executor. So while you appoint one person as your preferred executor, it will be good to also appoint another person as an option. And that is to guard against a situation where maybe your preferred executor is not available, is for some reason indisposed to, administer your will. So that way there'll be somebody else there who can step into that role. You know that by the time administering a will comes into play, the maker of the will is no longer here to make, additional choices. So it is best to clearly make those choices ahead. And it is also helpful to notify those people ahead and tell them that you are appointing them as executors in your will. That way, you are able to obtain their consent ahead, and then it will be easier to, for one to imagine that they will be willing to perform that role when that duty calls. Then the next thing will be to appoint, nominate guardians. And to nominate a guardian, this is important because in the event you have, young children or aged dependents who may not be able to make informed choices for themselves, or who are not yet of age to make certain choices or manage whatever it is you have bequeathed to them in the will, that helps to ensure that that guardian is there to administer that will for their benefit until they come of age or until they regain or acquire the capacity to do that for themselves. So if, for example, you have minors, children, young children, it is best to appoint a guardian. So that guardian will be the person who, in the event of death, ensures that those good thoughts, those things you want to ensure happen for your children, will happen for them even when you are not here. So it means that your children will not be exposed to undue suffering because they lost a parent or because they lost you. Of course, that's not to say they are losing you anytime soon. But yes, it helps to guard against eventualities, because death is indeed an eventuality, whether we want to acknowledge it, prepare for it, or not. And then, having listed your assets, it's important to also then leave instructions as to how you want those assets shared. And having listed your assets, listed your beneficiaries, appointed executors and guardians, it's important to then specify how you want your assets assigned. How do you want them bequeathed? Who are you giving what? Make your intentions clear. Make your intentions clear. The clearer your intentions are, the more likely that it is that your will not be contested. And of course, you should have witnesses who will, witness your signing of the will. That way, with all of these things in place, you see that making your will is easy. And like I said to you, it's an exercise that you can continue to amend, redo, or add to, or even remove from as things change. Maybe in the event of a divorce, in the event of the death of a beneficiary or an executor or a guardian, maybe in the event that your assets grow, or in the event that some of your assets are disposed of. In any of those eventualities, you can continue to modify your will or add codicils to your will. And then, of course, it's also important to store your will in a safe manner. So you can do that by maybe leaving it in a safe, or leaving it in a designated box, or even handing it over to maybe your attorney, or like some people may deposit in the bank or something like that. So leave it in a place where your loved ones will be able to access it when the need arises. So somewhere safe, but somewhere accessible when you are not there. So these are the things you need to put into consideration in making a will. And like I said earlier, it's really important that anyone who has attained any of the parameters I mentioned for qualification to make a will, you're over 18 years of age, you have a business or a career, you have some assets, some investments, you have earned, acquired some valuables, You have dependents, whether they're your children, loved ones, aged parents, or even pets. Anybody who qualifies on any of those grounds should have a will and may continue to amend the will as the need arises. And one other thing I didn't mention, which I would invite you for us to discuss in the next episode, is what I call digital assets. Because indeed, there is indeed digital assets. And it may also be necessary in planning your estate that you also deliberately plan for a digital asset executor. Join me in the next episode, and I'll be sharing thoughts on that and, helping you learn one or two things on the importance of the subject and how you can also go about that. Like I had said previously, please feel free to ask your questions, drop your comments, and you can also suggest conversation topics you'd like for us to take. And don't hesitate to always join us every Thursday at 10 p.m. as we discuss on the late night intercourse. Please click the subscribe button and also like to encourage us to come more. To encourage us to continue to bring you quality, enlightening, socio-legal topics that I'm sure will help you in one or more ways. As I had said in the beginning, still your host, Chioma Onyenucheya Uko, the Zest family lawyer. And I say thank you for being with me on tonight's episode. Bye-bye.